Welcome back to the number one podcast in Springfield. Rules of the Court, episode 4?
Yes.
Oh, yeah, week 4, episode 4. There's a lot of stuff to unpack today. A lot of things happened within like the last 2-3 days, like the last hour even, we're going to get to. But yeah, before we get to that, how has your week been? It's Thursday.
It is Thursday. It's been okay. I started working finally.
Yeah.
Yeah. How was your week? How was your week? Your week was exciting.
Yeah, I had a good week. My aunt welcomed a new baby boy, so it's been exciting. New member to the family. So that's where I've been the last 2 days. I was back home checking that out. But as that was happening, a whole bunch of stuff just has been going on within the world of college sports and sport law. But to get started, we'll start where we usually do, and that's with the Prairie Star update. What's going on with the Stars? What are they up to? Well, the men's golf team were able to finish 9th at the UNLV Fall Invitational. Jake Baldwin led UIS with a strong overall performance, finishing 22nd place with a total score of 213, including rounds of 68, 72, and 73. Nice. Julian improved during the tournament, tying for 33rd. Daniel Edwards performed well, finishing in a tie for 36. Brady Wilson scored a 224, good for Brady. And Shaka Lamraski finished with a total of 226. Oh, and he tied 39th with Tom, and Brady tied with Francisco Abba, who competed as an individual that week. Decent weekend for the men's. The women's, they secured 5th place at the Kansas City Cup. Good for them.
Nice.
UAS moved into 5th place early in the tournament, scoring 326 in the first round on Monday. They began the second round, but were unable to complete it before dark. The Prairie Stars completed the second round on Tuesday with a total of 319 strokes, tying their best score of the fall. Elaine Grant, who was tied for first after the first day, improved by 2 strokes in round 2. The team maintained its momentum again, totaling, that's a weird sentence, 319 in the final round. Elaine finished with a total of 225 strokes for 54 holes. Wow. Sarah contributed effectively with scores of 81, 80, and 83 for 23rd place. Araya Gattaker placed 29th. Ira Joshi finished 35th, and Isabel Siegel improved significantly in her final round, posting scores of 94, 85, and 80. Great job. Good to see that our golf teams are improving and are constantly improving and are playing some good golf out there. In other news, UAS soccer goalie Joe Brudnack was named Defensive Player of the Week in the GLVC. He's a freshman. Wow, freshman. I didn't even know that.
Nice.
I didn't know we had a freshman starting in goal. Yeah, Joe was pivotal in the 2 wins over the past weekend. 2 shutouts, might I add. In Friday's game against Truman, the guys won 2-0. And then in Sunday's match at Quincy, the guys got away with a 1-0 win again, 2 shutouts. Over the weekend, improving the Stars to a 2-2-1 overall record. So let's keep up the momentum. Sounds like we got a good guy in the net too. I can't wait to see him this Friday. That's going to be a fun game. The homecoming game.
Yep.
Ooh, that's going to be tough.
That's going to be tough. I think you said you were going to try to make it to the second half. Because it's at 7.
It's at 7:30.
Mm-hmm.
Women's volleyball is at 6. I want to try to make it to
know.
that game as
I'm going to volleyball.
soon as I can. That's a game I really want to go see.
To see my friend Rini.
Your friend Rini. Everyone's friend Rini. She's a very friendly person. But what was I gonna say? Yeah, I really want to go see that game. That game's at 6, but I have something going on at 5. But yeah, this is all speaking in reference to homecoming, which is tomorrow. Those are all homecoming games. Let me get that out. Women's volleyball is versus Missouri S&T. That's youth night for the volleyball girls. That's at 6 p.m.
Mm-hmm.
Sorry, this is just for my mental planning. And then, men's soccer's at 7:30. When's women's? Women's is at 5. There we go. Okay, so I probably won't make the women's game. Well, I mean, I'll be right. Nah, I can't. Wait.
No.
Yeah.
It'd be too much.
No, I'm saying, could I see it from where I'll be?
Oh,
I don't think I will.
no. You can hear it.
Probably. No, I'll keep track on my phone or something. But yeah, it should be a fun weekend of sports. Aside from that, this Saturday, September 28th, all day the men will be competing at the ITA regional. At 1 p.m. on Saturday, softball versus St. Louis Community College. That's a home game. And then the women have another home game. You can try to make this one. It's versus Maryville at 3 p.m. I can't. I work.
Saturday?
Uh-huh.
The soccer girls?
Volleyball. Maryville.
Oh. Yeah.
That's going to be a good game. You should go to that one.
Saturday? What am I doing Saturday?
Yeah. FaceTime me and then but don't put it on your face.
I don't have your number saved. I'm so serious.
You're so funny.
I know. Yeah, I'll probably try to go.
Stream it on TikTok or something.
Stream it on TikTok.
I think that's a question for when Mike Herman comes in next week.
What?
Is easier accessibility to watch the stars, especially for home games. It would depend on how we own the rights. This is genuinely a question then for Mike when he gets here. Is how does that work, and how can we make it more accessible?
He's like, I don't know, that's not my job.
He's like, dude, what? But anyway, back to what we were talking about. This weekend. Oh, and there's another men's soccer game at home, Rockhurst University. All right, so yeah, that's pretty much what's going on with the Stars. Homecoming weekend this weekend. Tomorrow, actually, the 27th. Today's the 26th.
Sorry.
All right, so what's been happening in the sport law world? Well,
A lot.
yeah. I don't know if you know, but do you know who Reggie Bush is?
Yes.
Who's Reggie Bush?
Football player.
Yep. Reggie Bush is one of the best college running backs of all time. He played for USC, and he played in the 2006 Rose Bowl, which is, I think, the greatest college football game of all time. There's a 60 for 60 on it. It's pretty good. You should, I think. Have you watched it?
60 for 60. You mean a 30 for 30?
A 30 for 30. I doubled it because it's that good.
What did you just say to me? Reggie Bush.
Have you seen, I think it's called the Trojan War, that 30 for 30.
Oh, I might have.
That's the one about USC versus Texas in the Rose Bowl at Vince Young. Yeah, but anyway, Reggie Bush, he was on the cover of one of the NCAA football games. He won the Heisman. He was the face of college football for a while. Well, as long as he was there. And it would later be discovered that Reggie Bush allegedly, I don't even think this was alleged. Reggie Bush took, I think it was I forget how much money, but he took money, some kind of housing arrangement, and a car from a sporting agent while he was in college. And the NCAA found out about that, and they shipped him of his Heisman and all of his records and stuff, and I think USC wasn't able to have any contact with Reggie Bush for 10 years. So he was completely annexed from the world of college sports. And this is while he was in the NFL too. So he was already playing for the Lions, I think. So boom, all of a sudden happens. Now players can get NIL deals, and Reggie is one of the prominent players that are saying, hey, what about us that had something that happened to us back in the day, or that weren't able to profit off of our names when we were big stars? What about us? Where's our money? So later down the line, Reggie was able to get his Heisman back because of the Alston ruling. They were like, oh, because it changes to whatever, and to what's it called, to it's their policies based on the ruling of the Supreme Court. He's able to get his Heisman back, but that pretty much didn't take away another thing that was happening. That was Reggie suing the NCAA for defamation. This is the first lawsuit that Reggie filed against the NCAA. And he basically was saying that, so the original statement from the NCAA that sparked this first lawsuit was, although college athletes can now receive benefits from their name, image, and likenesses through activities like endorsements and appearances, NCAA rules still do not permit pay-for-play type arrangements. The NCAA infractions process exists to promote fairness in college sports. The rules that govern fair to play are voted on, agreed to, and expected to be upheld by all NCAA member schools. And it is that claim of pay-to-play arrangements that has prompted Bush's defamation lawsuit. So basically saying that he was taking part in like pay-for-play arrangements back in the day.
Mm-hmm.
They're saying like that's still illegal now. Like you can't just, straight up pay someone to come play for the school. And to that, I mean, like, it wasn't the school directly paying Reggie back in the day anyway. It was a sport agency. I say that with quotes.
It was like a separate entity.
Yeah, pretty much. Like, cause it wasn't like there's like cases today where they're basically looking to fix that, looking to absolve that issue, and it'd be interesting to see what happens like after the House ruling, because that's pretty much what House is about. Is about separate entities or like collectives paying the college students to go play for the school. So if that goes in favor of the collectives and of the schools, then I think that gives a little bit of merit to Reggie's case here in this defamation case, maybe a little, because like his whole thing is basically saying that this is 100% false and not true. So I'm not too in tune with defamation cases, but this is one that's ongoing. Most recently on this case, the judge denied the NCAA's motion to dismiss the defamation suit. So this one is going to play out in the courts, and we'll keep an eye on it. Now, this new one, this is Tuesday. This happened the 23rd. So that's Monday.
Yeah.
Anyway, a few days ago, Reggie Bush filed another lawsuit against the NCAA, but this time for back pay, exactly what I was just talking about. Back pay for time that they missed on being able to get money from NILs. Now, this one is kind of interesting because I kind of fell into a rabbit hole of looking at what the response could be from the NCAA in this case. So basically, the gist of it is, coming from frontofficesports.com, is that the former USC star and Heisman Trophy winner has filed a lawsuit against his alma mater, the NCAA, and the Pac-12 over exploitation of his NIL. This lawsuit is similar to the ones filed this summer by players from the 1983 NC State men's basketball team. All right, so basically in this case, in the second case, Reggie is seeking what's called unjust enrichment, and that's like basically looking for damages that have been brought upon you, but you haven't been realized you've had damage done against you. If that makes sense. That was very poorly worded. Yeah, that would. So basically, it's like if I built a house, but you didn't pay me for it.
Oh.
Reggie played football for USC, the Pac-12, and the NCAA, made them a lot of money, and he wasn't paid for it. That's what he's looking for. Now, there are a couple of main like defenses to this, and the one that I think that the NCAA is going to lean pretty heavily on is the timeliness of this.
Why?
Okay, so the way the timeliness defense works is that really there's two main rules that you use to apply it, and that's the injury rule and the discovery rule. The difference between the two is that I believe so. Regardless of either two rules that you follow, there's a 4-year, period or statute of limitations of which you can file the case. So the injury rule is applied, and the statute of limitations begins the date the plaintiff is injured. So, like, I guess if we were to apply the injury rule here, it would be the date Reggie first started playing football for USC. Now, the discovery rule is a little bit different in that the statute of limitations begin when the plaintiff realizes he was injured. Now, that's where I think it can get tricky because
I never thought about those differences.
Yeah, because depending on how this is going to be judged and how, like, in what rule is going to be used, I would have to look at what court, because that's another thing too. I would have to look at what court they're in and like in what district they're in to see what rule applies, basically, like what's precedent there for them to
Mm-hmm.
use. And obviously, the discovery rule would be more beneficial to Reggie here in deflecting that objection from the NCAA. But even then, it's like, okay, so is it 4 years after you left college? Is it 4 years after they took your Heisman away? Is it 4 years after the ruling of Alston? Is it 4 years after, you know, after you first start? Is it still, 4 years after you were caught or like in that investigation began into you in your college days? It's weird to have to kind of do that like
Go
circle
back.
of like, yeah, okay, was it back here? No, it's back here. If it's back,
Mm-hmm.
so be interesting to see in which like and how both sides. Well, I think it's pretty like straightforward how the NCAA is going to argue it. They're going to say no. It's first of all, you haven't played college football in like 20 years, dude. um,
Dude, yeah.
Secondly, regardless of when you found out you were injured, or like that's going to be a whole other situation, which I think they're going to have a pretty strong argument against. And or rather they use the what's it called, the injury rule, and you have 4 years from like when you started playing football or whatever. When you stop playing football, it's like even then you're out of time and you took too long to figure this out. And then another thing I read that the NCAA might be able to try to like invoke here is the fact that Reggie accepted NCAA membership back when he played. So like, or the rules of NAL deals and stuff like that, and their statutes back then. But yeah, so basically, like the NCAA could argue that in the time that he played, they were in compliance with the laws at the time and what law was applied to them, and whether antitrust law applied to them or not. Then it wasn't as big of a question, and the rules weren't brought to light as much as they are today. So they could pretty much say you agreed to it then. Why would that change anything now? And another thing too, regarding going back to the House case and the 2 point whatever $1 billion, 2.78 I think it is $1 billion. That only goes back to players that played up until 2016. So
He's
that's I think
out.
yeah, he's 10 years
Yeah.
prior to that. So I think that well, obviously that's like the big reason he brought this case in the first place, because he wanted a piece of that pie. But like think about it, like they already have to pay over some period of time. It's still getting sorted out by the courts and by both sides. But they would have to pay that $2.78 billion over however long. And now you have guys like Reggie Bush coming back and saying, "Nah, I want, I
I
want two."
want.
And you have the NC State basketball team who also did the same thing. I think that case was actually settled too, and I think they got some money out of the NCAA. So the NCAA is paying a lot of people a lot of money within a very short period of time.
Yeah.
Like,
They're gonna say no to everybody.
yeah, and they're gonna say, and then everyone's just gonna bring them to court,
Yeah.
and then they're gonna be forced to pay them, and then
Wow.
probably go bankrupt pretty soon.
They go bankrupt, and then what happens?
I would assume that like one of the big conferences take over, like the SEC or the Big Ten, or they like just merge and make one big one, like we talked about last semester.
Mm-hmm.
There's a lot of talks about them coming together and like pretty much controlling college football. Um, but yeah, I haven't checked on that in a while, but
It's like they're already merged.
yeah, they're one division. They're the big SEC.
Everybody's waiting for us to talk about it.
Yeah, nah, the big SEC hasn't happened yet, I don't think. And I also think another thing too that kind of goes against Reggie here is that there's a lot of precedent on the NCAA side. So, so one thing that I read on what's it called, Sportico, was if the NCAA could reference Marshall versus ESPN, in which the Sixth Circuit rejected a lawsuit brought by college football players demanding compensation for televised appearances. And the judge here reasoned that the system where a network must negotiate with players would be unattainable, since it would require all of them to agree, and referees and coaches and fans might also seek payment, which I think, like, what? Like, no, that doesn't necessarily make a lot of sense to me, because no one's saying that, like, people in live audiences should seek compensation for being on TV. Well, actually, I would assume that they all like signed some kind of waiver anyway.
It's probably like when you get the tickets, similar to like when you get
Yeah, I mean, like even
tickets
yeah,
to a concert.
yeah,
Coming to school here, you like are
You-
kind of saying yes, use my face for whatever, I guess. Unless they specifically be like filming you or anything.
yeah. That's why I don't think this judge's ruling here kind of makes sense at all to me. But it's precedent that works in their favor, if in the
Yes.
favor of the NCAA. So, yeah, that's what's going on with Reggie. With Reggie Bush, and now his second lawsuit against the NCAA, and both are ongoing. All right, the next thing on the docket, the Pac-12 suing the Mountain West Conference. So, do you know what happened to the Pac-12?
I don't even know what the Pac-12 is, bro.
The Pac-12 is a collegiate conference. It's a Division I conference. Well, I almost said it was. It technically is right now. So like almost all the schools left for the Big Ten. I don't know, like Oregon came over to the Big Ten, and like a bunch of big schools came over, and they were essentially left with two schools, and they are where are they? It's Oregon State and Washington State. Those are the last two schools that stay within the Pac-12, and they had a whole legal battle, and like they did like this whole like divorce settlement thing with all of the other schools that left, because it was obviously it was a majority of them.
Who gets to keep what?
Yeah, no, literally that's what happened. And these two schools were able to keep the marketing and like the logos and stuff of the Pac-12, because if those schools that left were to have got that in the divorce, then they were able to shut down the Pac-12 completely. These two schools, Oregon State and Washington State, were like, no, we're staying. No, we're staying, and we want everything that basically is associated, like all the intellectual properties of the Pac-12, so we can preserve it. We're going to try to make something out of this. We're going to try to save it. So the way that they're trying to save it is kind of shady. Like, it kind of like makes me wonder who's running things over there. And it kind of makes me wonder about the teams that left and what they would have to say about this. Because what happened is these two schools, Oregon State and Washington State, I guess pretty much negotiating as the Pac-12 themselves. They began negotiating with the Mountain West Conference, which is also a conference. So the Pac-12 and the Mountain West are all on the West Coast or Western region. They started negotiating with the Mountain West Conference, saying, "Hey, there's only two of us here, but we want to play. We want to play football. We want to play baseball. We want to play basketball. Include us in your conference schedule, and we can come up with a deal, where we are allowed to allowed to like negotiate with some of your schools to bring them over to the Pac-12 for a fee." And I think someone would like the fee was like $10 million for the first school, and then it increases by 500. 500. I think it's like 5 million. I gotta find it.
But it increases with each additional school?
Yeah. It was $10 million for the first school, and then it increases $500,000 for each additional school. So what happened was the Pac-12 started buying up a lot of schools, basically. They went for Boise State, Fresno State, San Diego State, Colorado State, and that totaled up to $43 million, and they added Utah State later on to a total of $55 million. So that's how much they owe Mountain West, the Mountain West Conference. And then, so basically when the Mountain West Conference sent them the bill, the Pac-12 was like, no, wait, why? We don't owe you this. This is like the deal we signed was illegal. And the Mountain West was like, what?
Wait, but why was the deal illegal?
Because they say that the provision that they signed, because they pretty much are arguing that the deal that they signed was unlawful. So the actual like provision is called the poaching penalty. They're saying that is an unlawful and a draconian exploitation of the conference, of the Pac-12 conference, because when the Pac-12 signed that agreement, they were saying that you basically got us like at our weakest point. The MWC imposed a poaching penalty at the time when the Pac-12 was desperate to schedule football games for its two remaining members and had little leverage to reject its naked restraint on competition. which would be an antitrust violation. But this does not make the poaching penalty any less illegal, and the Pac-12 is asking the court to declare the provision invalid and unforeseeable. Unenforceable. Jeez, dude. Unenforceable. So basically here, like the first thing that I thought of is like, well, okay, you signed the contract.
Mm-hmm.
And you know it's illegal. Or you're arguing it's illegal.
Why'd you sign it?
Yeah, exactly. Why'd you sign it? You know, you can argue all day, oh, but we were vulnerable, or we like, and I don't even think that they were like that, like they were super crazy like stipulations either.
Mm-hmm.
There very often are like release clauses that come with moving conferences. But I think where the Pac-12 could have a little bit of merit here is arguing torturous interference against the Mountain West Conference. Now, what torturous interference is basically it's a claim in tort law that says that, you know, if you and I are trying to make a business deal and we have a friend over here and this friend over here gets in the middle, is like, no, you're only gonna negotiate with me. You know, we have this deal, we have this. Torturous interference is basically cutting off that line of, you know, business between two people intentionally and wrongfully. And I do have it up here. Torturous interference is a common law tort allowing the claim for damages, so you can receive damages for someone doing this to you, who wrongfully interferes with the plaintiff's contractual or business relationships. So I think that's where the Pac-12 is going to head with here, or that's where the Pac-12 is going to head here with this case, is arguing that there has been torturous interference between them and the schools, the schools that they're trying to get, you know, into the Pac-12, and the Mountain West Conference is the one interfering with this poaching penalty. But you know, I don't know. Given my early prediction here, this literally just happened 2 days ago today. So this is a really, really, really early prediction of how this is going to happen. I think this one's going to go to court, and I think the Pac-12 is going to have a little bit of a case to argue here. But I think it could. I think what's going to happen, it's going to set precedent for these kinds of contracts and negotiations that can happen between conferences and poaching, especially now in this new day and age where it seems that, you know, having money at your school is going to be a pretty big deal, you know.
Yes.
So I think that's going to play a big role in it, especially considering that is the very near future.
Yeah.
But anyway, yeah, that's what's going on between the Pac-12 and the Mountain West. All right, the next thing that has been going on in college sports is the couple of UNLV players have been opting out of their season amid NIL fiascos, according to SI. Two of them entering the portal. The first one being their starting quarterback, Matthew Saluka. He entered the transfer portal, and his is a little bit more entertaining than this most recent one. Running back Michael Allen. I think he's like the fourth leading rusher of their team, I read.
You sent me this, right?
Yeah.
On Instagram. It looked familiar.
Yeah. He went into the transfer portal. Because he posted something to Twitter that was like, "Oh, this has nothing to do with the Saluka's situation and his NIL situation." I think his was just, you know, a situation where he wants more playing time, and it just so happened to happen so close to Saluka going into the portal. Now, Saluka's is a little more interesting because he's going into the portal alleging that the school and their collective, I think it's like football families or friends of UNLV. Yeah, Blueprint Sports and Friends of UNLV. He's alleging that this collective never honored, I think it's like $100,000 paycheck that he was supposed to get for coming to play. And now UNLV's reaction to that was pretty much, first of all, buddy, that's pay to play. We can't do that yet. We're, you know, following the rules of the NCAA. We're following the rules of our school. We're following the rules of the state of Nevada even, that says that we can't, you know, just pay you to come and play for our school. That's us nor our collectives that are partnered with our school or that, like, you know, have an interest in our school. And even the collective came out and made a statement at Blueprint Sports and Friends of UNLV. We take our commitments very seriously. We would like to emphasize that we have upheld all Friends of UNLV contracts this season, and we have not defaulted on any agreements with Mr. Saluka. Our commitment to supporting Rebel student athletes remains unwavering, and we are dedicated to maintaining the integrity of our programs. So they're pretty much saying that, dude, we never even had a deal. What are you talking about?
Yeah, because I saw on Instagram that it was like a verbal agreement.
Yeah, it was like I guess it was like a under the table handshake, or even then, like
It was
doesn't
literally
necessarily. Yeah,
not
I
on
think
paper.
if there's no proof that this was on paper and like done, then well, duh. So Lucas should probably shut his mouth. And
Yeah, because they
yeah, I don't
could
mean that
have done a
aggressively,
deal.
but like he should like not, be claiming that this is the issue. But if it is on paper, then I think that UNLV and their collective more specifically has some questions to answer about not giving this kid his money. Because then that would be a serious issue, and that's an issue that I think that is the most scary about this new NIL world, and that these kids are dealing with things that they have never thought they'd have to deal with. Like if what he's saying is true, and I hope it isn't, because then that means that he's getting cheated out of money. If what he's saying is true, then this is like one of the first big examples in public examples of a student, entering an NIL deal and getting cheated out of it, or a student not necessarily understanding completely the ins and outs of a deal that he may have entered or may have not entered,
Mm-hmm.
So I think this is a learning lesson for both sides here. We'll see how it plays out. I think there just needs to be more information coming out of it. This was, these are articles from yesterday, so this is still very much playing out, and we'll see where that goes. Okay, so in other news, do you remember when we talked about Dartmouth and the NLRB saying that the basketball players are employees?
Yes.
Yeah, this was last semester, and now Dartmouth came back, and now they're challenging that ruling, and they basically are going to court, and they're
Wait.
using a recent Supreme Court case to argue that because of an ambiguous definition of a term in a like within a policy or within a law, we shouldn't have to defer to the agency's ruling, or to private agency's understanding of the term. And that's basically what happened here. There was an argument on what the term employee meant between the NLRB and I guess Dartmouth. And the NLRB said, well, no, we're the agency. We're going to tell you what it means. Now, there was a Supreme Court case in 2016, Looper Bright Enterprises versus Raymundo. Sure. And the holding there in that case was that the Administrative Procedure Act requires that courts exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. So the statute that is ambiguous here is the definition, or I guess the classification, of an employee. And Dartmouth is saying that, well, because of this case, this Supreme Court case that ruled on an independent agency's ability to, I guess, define ambiguous terms, we're saying that that term, employee, is ambiguous enough for us to either go to court or have it be reviewed by the courts, and not the NLRB itself. And I think it's interesting to note here how like independent regulatory agencies exist mainly to be like very specialized in the administration of a specific subject or sector of the economy. And the NLRB obviously is focused on labor and organized labor and like unions and stuff like that. And that's like their whole wheelhouse.
Mm-hmm.
So like another thing too is these agencies are meant to be apolitical because they're independent from the executive, the judicial, and the legislative branches. They're meant to just, work and function within their specialties. So I think my opinion is I would have to look into that Supreme Court case a little bit more to understand what the ruling was, what the reasoning is. But to me, I would think that like the agency that specializes in labor would know how to classify an employee. That's just my opinion.
True.
And I don't know what Dartmouth is really hoping to get out of this, because then I think if it comes to like some kind of dispute where it's going to be the NLRB versus Dartmouth over the definition of what an employee is, and whether the NLRB can enforce employment employment and labor laws against the school for not allowing the students to collectively bargain and things like that because they don't recognize them as employees. If they go to court over that, I think that still is a losing case for Dartmouth, because then that is just basically going to make the court this. I think it would probably eventually end up in some kind of federal court. Well, yeah, it's an NLRB case.
NLRB.
National Labor's Relation Board.
Okay.
Yeah. So,
Oh, and then that's why Dartmouth and them.
yeah, because they're the ones. The
Who's the
NLRB
employee?
is the one that originally said that yes, the basketball players are employees because how much money you make off of them, yada yada yada. And Dartmouth is trying to say that no, you don't have authority to give a definition of this ambiguous term. Yeah, exactly. See, you made a face, because it's like, well, why wouldn't they have the authority if they are the authority of
Labor.
Yeah. So yeah, I think that regardless if this goes to court, I think it's still a losing case for Dartmouth. If anything, this is just like to prolong that, because I personally believe that student athletes should be classified as employees,
Yeah.
at least at some capacity. At all levels, I don't know. I think it would have to depend on like.
You mean at all levels, like UIS and USC, like completely different levels that they're on?
Yeah, levels of like revenue generation.
Yeah, yeah. I
Because
agree.
then that's another sticky question, how that would affect different sports, and then the separate genders between the two sports, or the separate, and how they would make money and things like
There's
that.
like a lot to it. Every time you pull one thing out, it's just like.
Yeah, see, now I'm even questioning myself, like, do I really think that?
Do
No,
you?
I'm staying firm on it. Yeah, I think that they should be employees.
Next episode, you're like, nah, they're
Nah,
not.
what? Why?
You talk to Mike. You're like, nah, no NIL.
I hate NAL, Mike. Nah, I wouldn't turn.
Nah,
I wouldn't
I
turn
think-
face like that.
Publicly. No, just kidding. But I think they should be employees. We talked about this. We talked about a lot of things about this last semester, like
Yeah.
the cheerleaders. Literally
Like who else?
everything.
Who else could like argue that they should be employees too?
Yeah.
But I think that in this world that we're talking about right now of just college sports, I think it will happen eventually. How it's gonna happen, I don't know.
What? That they're gonna be classified as employees?
Yeah. Because if the NCAA doesn't want it's gonna end up becoming a pay for play if they're employees. Well, hold on, no. Let's think about this. I think that like they can there's still a possibility in which like they can pay their student athletes for uses of their name, image, and likeness in like whatever capacity, like instead like a minimum wage salary for them for however long that they play. And that's just like, oh, we can use your name and your face on like advertisements for games and whatever.
Do you think? Well, nah, because I was gonna say, do you think it should just be like the minimum wage, like what we both technically get paid for being employees of the school, but then the what did you say, revenue that they're generating is like a lot higher and worth a lot more than what.
Well, I think here's the thing. I think that like individual players shouldn't come from the school. I think that that's where the collective comes in, and especially sponsorships. If they can make that money outside of school and they go wherever they want to go to, then I think honestly in that case, then there really should be like a lot of reins placed on the collective, because I don't think the collective should be willy nilly spending money on star athletes to come to their schools.
Yeah.
I think it should be like Taco Bell or Verizon, or I think it should be those. I think it should be those kinds of sponsorships, like actual sponsorships where the athlete has to deliver something in return. Are the only other ways that they can
Provide back.
Yeah, but we got off the track there. So that's been what's happening with Dartmouth. They're challenging the NLRB's ruling. I think regardless is going to end up in a win for the NLRB. But this one is going to take some time to play out with the way that it's going. Because then, regardless of who wins, well, no, I think that in the case that the NLRB wins, then it's going to be a whole other thing where then they're going to have to negotiate with the students to create a CPA, and yada, yada, yada. So this is going to take a lot of time. And finally, we made it. The last thing on our list to talk about. And that's pretty much a live reaction right now to the UFC settlement of $375 million to one of their two antitrust lawsuits. So there were two antitrust lawsuits brought against the UFC, basically saying that the UFC existed and acted as a monopoly, and that pretty much limited the fighters' ability to maximize their earnings. Initially, there was a settlement reached way back when, not way back when, but I think earlier this year. And that one was for how much? I think it was like right here, $335 million. And that was to settle with two cases that were brought together. And that was a case brought by Chung Lee and another case brought by Cajun Johnson. So that one went back to the judge, and the judge said no, renegotiate both of these basically, and they were able to come out with an even higher payout to only one of the settlements, the Lee settlement, or the Lee case. But yeah, that case started way back in December 2014. So not only did that case include Lee, but it also included John Fitch and Nate Quarry, who are fighters that I'm a little bit more familiar with. But yeah, same thing. They accused the company of antitrust violations, anti-competitive practices, if you will. Yeah, that one ended up getting bundled into the Johnson case, but it seems that they're only able to settle with Lee in this case. But yeah, they got a lot of money to pay out. I mean, this is pretty much how it's been with almost every other settlement that we've talked about, and this is just a settlement so far. It still has to go back to the judge again, and he's got to approve it, and he could deny it again. And
then what? They just keep renegotiating it, or at one point they just drop it? Like those are
that's
the
a
other
good
two.
question. There's no limit to the number of times a civil settlement can be negotiated or renegotiated, excuse me, as long as all parties are involved are willing to do so. So.
But that's also a lot of money.
Yeah.
On both ends.
Yeah.
So.
Well, because I would assume this has something to do with like treble damages, which is pretty common in antitrust cases, which is basically triple the amount of damages that are like found to be owed to the injured person.
Mm-hmm.
So I think that's pretty much what happened here, and they were like, "Okay, Mr. Lee, you can get all of it."
Take it all.
Pretty much, but that's what's going on with that one. The Johnson case, I assume, is still ongoing then, or at least they're renegotiating that one still. And it'd be interesting to see how much the UFC is going to have to cough up for that one. Or I guess TKO, the parent company of the UFC, would have to cough up for that one. But yeah, a whole lot of stuff going on, dude.
And Derrick Rose retired.
Oh, one of the greatest to ever lace him up for the Chicago Bulls. Derrick Rose. Well, all right, yeah, that's everything that's going on. Pretty big week for college sports, but yeah, You ready to have a good weekend?
Yeah, it's Thursday.
Almost Friday.
Almost Friday.
Almost Friday. You guys have a good one. Adios.
Bye.